Ladies and gentlemen, good afternoon. So welcome back to the Hong Kong Legal Week 2024. The afternoon sessions of the Asia Pacific International Private Law Summit 2024 will start in a few moments. So please kindly be seated. Once again, please remember to switch your mobile phone into silent mode. If you would like to obtain the CPD or ALE points for this summit, please remember to sign in at the reception. 各位來賓，大家午安，歡迎大家返嚟香港法律週2024亞太國際司法峰會嘅會場。咁下晝嘅環節咧，好快就會開始㗎啦，有請各位盡快就座。咁再次溫馨提示咁多位，記住要將你哋嘅手提電話調至靜音模式。另外，如果要取得 CPD 或者 ALE points 嘅話咧，記得要去到我哋登記處嗰度咧去登記入場啊嚇。各位來賓，大家午安，歡迎大家回到香港法律週2024亞太國際司法峰會的會場。那麼下午的環節馬上就會開始，有請各位盡快入座。再提醒各位的來賓們，記得要把你們的手提電話調至靜音模式。另外，如果要取得 CPD 或者 ALE 的分數的話，請記得要在登記處那邊登記，謝謝。 Ladies and gentlemen, good afternoon and welcome back to the Asia Pacific International Private Law Summit 2024. So here comes our third panel discussions on Gateway to International Investment and Sustainability. So already on stage, we have our moderator, Professor Ignacio Tirado, Secretary General of UNITRA, and also our distinguished panelists, including Dr. Li Miao, Legal Director of China Merchants Port Holdings Company Limited, Mr. Anthony Crockett, Partner and Asia ESG Lead at Herbert Smith Freehills, and also Professor Anna Veneziano, Deputy Secretary General of UNITRA. So if you have any questions for our moderator and panelists, please submit them through our online form by scanning the QR code here on the screen on your table all around this hall, and they will be addressed accordingly. And for our online participants, the QR code should be displayed on the screen. And now without any further ado, should we all give a big round of applause and pass it over to our moderator.
Thank you very much. Good afternoon. Here we are again. Thanks for coming back. This new panel, the third of the day, follows nicely from the content of the previous panels. As was mentioned, it's entitled Gateway to the International Investment and Sustainability. So it's part of the law and sustainability, part of the work that not only our organization is doing, but so many organizations are doing nowadays. And we are going to be focusing on international investment and sustainability and the sustainability goals, but also having a local perspective so that we can have a complete overview of the topic. First with us, the first speaker, going to, with your indulgence, alter the originally envisaged order of speakers. First one to speak is going to be Mr. Anthony Crockett, who is Partner in Asia ESG Lead of the global law firm Herbert Smith, and he's going to be talking to us about international investment law in tension, asking with sustainable development goals. Anthony, the floor is yours.
Thank you, Ignacio. Thank you to UNITRA and the DOJ for inviting me. So we have some slides, I think. Can we have the slide presentation on the screen? Good. So I'm going to talk for about 15 minutes. I'm conscious that the summit is a summit on private international law, but I'm going to start with some brief remarks on public international law, really just to underline how sustainability has become an express objective of international investment law, and of course, increasingly of regimes that we would consider private law. To then look at the development of standards, starting with soft law, but then moving increasingly into hard law and regulation to ensure that private enterprises are adhering to standards of responsible business conduct in order to achieve sustainable objectives, and in particular, in order to avoid adverse impacts on the environment, on society. And then very briefly towards the end, some comments on what the implications of these developments might be for private law, and which the other speakers will then discuss in some further detail. So we'd be here all afternoon to talk about the history of international investment law. What is it? It's the body of international law which governs how states should treat foreign investors. So the host state, which is receiving an investment, it's the set of rules which govern what that host state may do or may not do in terms of its treatment of that foreign investor. And that body of international law consists both of customary norms, but also the provisions of multilateral and bilateral investment treaties. And investors, of course, and this is something, the history of investment contracts predates the development of international investment treaties, but investors may seek to protect their investments through contracts. So they enter into a contract with the host state or with some organ of the host state that sets some rules about how that investment will be made and how that investment might be treated. And some of the protections that international investment law gives to foreign investors includes prohibitions on discrimination on the basis of nationality. So a foreign investor should not be treated differently from a domestic investor. Prohibitions on expropriation of investments. The investment may not be taken or seized by the state, except subject to certain conditions, including that it be for a public purpose, including that compensation be paid. And then other protections include protections against arbitrary or unfair decision-making by administrators, by judges in some cases. And investors might be able to enforce those protections by submitting claims to international arbitration. And so you hear about so-called investor-state arbitration, investment treaty arbitration, where foreign investors bring claims against governments alleging that these standards of protection have not been adhered to in respect of their investment. And starting in the 1990s, concerns began to be raised that this system of protecting investment was at odds with the objectives of sustainable development. And cases that were criticised in particular involved investors bringing challenges to environmental regulations and saying the introduction of new environmental regulations in this state, which affects my investment in some way, is a breach of the investment treaty. And then they would bring a claim under the investment treaty, seeking compensation, sometimes in fact seeking the repeal or the exemptions from those new regulations that had been introduced. And what that criticism of international investment law from a sustainability perspective has led to has been some quite significant and reforms to the system, both at the level of the system of investor-state dispute resolution, and so we've seen the introduction of rules around transparency, rules allowing for third parties to participate in these disputes, in particular to ensure that issues of the public interest are raised in those disputes where relevant. At the level of treaties, you see sustainable development being mentioned as an explicit objective of the investment treaty, is to encourage or to facilitate sustainable development. You see provisions increasingly in investment treaties which set out expectations about how investors will conduct themselves, that they will comply with international standards relating to sustainability and relating to responsible business conduct. You see treaty exceptions or reservations which prohibit or prevent investors from challenging sustainability-related regulations. Regulations, for example, relating to the environment, relating to public health. And then you see provisions, and I think this is probably the cutting edge of these reforms, provisions which would allow host states or even third parties to bring counterclaims against investors where those investors have caused harm to communities or caused harm to the environment through a failure to adhere to international standards. And so really some quite significant reforms of the system or the regime of international investment law with the objective of ensuring that investment supports sustainable development. And just to give an example of that, this is a provision from the China-Angola Bilateral Investment Treaty signed last year, or from the preamble, and you see explicitly the objectives of promoting investment in a manner consistent with the protection of health, safety and the environment, and an express recognition of the right to regulate and to preserve the parties' flexibility to regulate in the area of sustainability. Now, I mentioned that in the context of international investment law, there were the criticisms in the 1990s that the system didn't facilitate sustainable development and was in tension with the objectives of sustainable development. This is the potential for investment both to contribute to sustainable investment, but equally potentially the harmful effects of foreign investment have been recognised, in fact, for a very long time. In 1976, when the OECD Declaration on International Investment and Multinational Enterprises was signed, that instrument expressly recognises that the positive contribution of international investment to sustainable development is not always guaranteed. And so, of course, you need investment to achieve sustainable development, to invest in infrastructure, to invest in technology. But of course, if that investment is not responsible, you may in fact not achieve the sustainable development objectives. And so the OECD guidelines for multinational enterprises were developed, and they comprise recommendations by governments to multinational enterprises about responsible business conduct, and with an objective of avoiding adverse impacts on society, avoiding adverse impacts on the environment. And the OECD guidelines, they are not binding, but they were given some teeth in the form of a complaints mechanism, and where members of the public, NGOs, trade unions might bring complaints against multinationals where they see that the standards are not being complied with. Then come forward to 2011, and the UN Guiding Principles on Business and Human Rights were adopted unanimously in the Human Rights Council. They explicitly call on business enterprises to respect human rights and to ensure that through carrying out human rights due diligence. So having policies and processes in place to ensure that their business is operating in a responsible way. That same year in 2011, the OECD guidelines were revised and now expressly incorporate the due diligence recommendations from those UN Guiding Principles. Then in 2017, France made environmental and human rights due diligence mandatory for large companies. And that was France was the first country to introduce mandatory sustainability due diligence law as a form of regulation. And then this year, and this directive entered into force in July, the European Union adopted what's called the Corporate Sustainability Due Diligence Directive. And that will make it mandatory for EU companies, but also non-EU companies. So it's an extraterritorial instrument. And if you generate more than 450 million euros in annual turnover in the European Union, you are in the scope of this directive. And it will require companies to adopt and implement due diligence processes to identify and address adverse human rights and environmental impacts, and throughout their whole value chain. So not only in their own operations, but to address adverse impacts which may occur in the supply chain or in some other part of their value chain. An obligation to adopt and implement a climate transition plan, and then an obligation to publicly report on an annual basis on how they are fulfilling those due diligence obligations. And so the European Due Diligence Directive, this is currently the high watermark of regulation in the area of sustainability, the idea of imposing an express obligation to carry out due diligence to avoid adverse impacts on the environment, on human rights, an accountability mechanism, reporting mechanism built into that legislation. Similar legislation is being proposed in other parts of the world. There is a proposal in the South Korean parliament to introduce a mandatory due diligence law. There's a proposal in Chile and Latin America to introduce a mandatory due diligence law. So this is now a regulatory trend that you see around the world. The directive is accompanied in the European Union by the Corporate Sustainability Reporting Directive. So two pieces of regulation that work together. The Corporate Sustainability Reporting Directive requires companies to report annually on their environmental impacts, on their human rights impacts. It's not to report on their corporate social responsibility activities. It's an obligation to report on adverse impacts and what is being done to manage and mitigate adverse impacts. That reporting obligation we see being introduced all over the world. So some countries we don't yet have a mandatory due diligence obligation, but we do have a mandatory sustainability reporting obligation. And Dr. Lee will talk about what's been introduced in Hong Kong. We have mandatory sustainability reporting being introduced in mainland China, in Japan, in South Korea, in Southeast Asia. Everywhere in the world we see these reporting regulations being introduced. And so what are the implications of this for private law? We see this shift. We had a range of voluntary standards that companies were encouraged to comply with respect to sustainability, being replaced by regulation which requires, in the European context, due diligence, but almost everywhere requires reporting and disclosure on sustainability matters. And we see that those, almost everywhere when those regulations are introduced, they apply to the entire value chain. So you have to report on sustainability matters, not just in your own operations. What are your suppliers doing? What are your joint venture partners doing? What is your wider impact? And the practical consequence of that style of regulation is that companies require cooperation from a whole range of business partners to implement those obligations. So you need your suppliers to cooperate with you, to provide you with information about the sustainability issues, to cooperate with you sometimes if you need to put in place risk mitigation measures or remedial measures. You need that cooperation from your counterparties. And commercial contracts play an important role and will play an increasingly important role in helping companies to carry out those sustainability-related obligations. And so examples of the types of provisions that will need to go into contracts, obligations to provide information to enable reporting. So emissions data being a good example. Obligations to implement or to follow relevant international or industry standards. So asking a supplier to agree in the contract that they are going to apply and implement and follow a particular standard in order that you can be confident that there are no adverse impacts taking place in that part of the supply chain. Provisions then for monitoring and auditing that performance. So a provision in the contract which allows one party to go and conduct an audit or conduct monitoring, do some sort of follow-up to check that those provisions are being adhered to. But also provisions which, and this is something that's explicitly been recognised in the European context, that the potential for this type of regulation to become quite a heavy burden down the supply chain on smaller enterprises, but provisions that allow the larger corporations at the top of the supply chain to share resources and capacity and expertise down the supply chain to ensure the achievement of sustainability objectives and to ensure that standards are being complied with. And so this is in the context of commercial contracts. I mentioned in the introduction, a lot of international investment also involves contracts, and those contracts increasingly are going to need to have sustainability provisions as well. And then finally, I think something to recognise, because as I said, this will become more and more important, that we think about these provisions in contracts. Like all provisions in contracts, they will generate disputes. And it will be important in that context to recognise that issues of wider public interest may therefore become implicated in the resolution of what is otherwise a commercial dispute. And the risk that what we do with private contracts, that we end up with the similar criticism that we saw in the investment law regime, where there was dispute resolution and enforcement interpretation of these treaties going on without adequate consideration being paid to the public interest considerations. And that will be a risk as well as we see sustainability-related provisions being included more and more frequently in our commercial contracts and agreements. Thank you.
Thank you very much. This presentation tags on perfectly with Professor Veneziano's presentation, because two things were touched upon: investment treaties and contracts with governments and government agencies. and how sustainable development goals can be incorporated into those, as well as the whole supply chain. And that's precisely the two instruments that UNIDROIT is working currently on. So another.
Yeah? Okay, perfect. So thank you very much, Ignacio, and good afternoon, ladies and gentlemen. And thank you very much, as Ignacio said, to Mr. Crockett, because he has anticipated a few of the themes that I wanted to treat, so he has greatly facilitated my presentation. And in particular, the first point that I wanted to make, which is the fact that private and commercial law can play an important role as a means to foster sustainable development alongside regulatory and public law. And this is exactly what UNIDROIT's instruments are trying to do. And generally speaking, our instruments, as you have seen also in the other panels, offer an enabling harmonized private law framework for domestic and international private business finance to achieve, generally speaking, developmental goals in the area of access to credit, capital markets, private law in agriculture. But what I would like to focus on now is on those specific instruments and projects that are relating to investment contracts. And those are the two projects I would like to focus on in particular. One already adopted, the first one, the other in the making. It's a project. The first is the UNIDROIT IFAD, the International Fund for Agricultural Development, the UN, of course, agency, legal guide on agricultural land investment contracts, the ALEC guide, which was adopted by both organizations in 2021, which is a legal guidance document focusing particularly on investment on agricultural land. And we also had the active participation of FAO, because this is the second legal guide of a group of 3 instruments that we have developed and are developing with the 2 Rome-based UN agencies dealing with agriculture. And then the second, it's a project, the UNIDROIT ICC World Business Law Institute on international investment contracts, started in 2023. It has already gathered a lot of attention. We have many experts, including actually Professor Chin-Len Lim, who is from the Chinese University of Hong Kong. But for it has attracted so much attention that UNIDROIT has also created a consultative group where experts nominated directly by member states and even some non-member states are asked to provide advice and consultation on the documents produced by the working group. So those 2 instruments, or the second projects, have some differences. First of all, one is already adopted, the other is in the making. Secondly, they have a difference in the scope of application, because one is more specific to land investment contracts, the other is more general on commercial investment contracts. And they also are different in the expected outcome, because the first one is a legal guidance document with a narrative form following the life cycle of the contract, while what we are expecting the new project to produce are non-binding principles, rules, but also model clauses, because it's together with the ICC, applicable to international investment contracts in general. But they also have some elements in common. First of all, they are a joint venture with other intergovernmental or international organizations providing expertise on the practice in different jurisdictions, and this is something that we are trying to develop also with other projects, and they are based on existing uniform general contract law developed by UNIDROIT, and in particular the UNIDROIT principles on international commercial contracts. And this is why I have a short slide on the UNIDROIT principles. This is the cover of the Mandarin translation of the principles, translated in more than 17 different languages, non-binding soft principles and rules covering the most important aspects of general contract and obligation law, and developed in a way to be neutral, balanced, and practice-oriented. Now, why am I mentioning these principles? They were the point of reference for the project on investment contracts, but I'm mentioning them because they are already applicable to investment contracts, and we have more than 40 cases of their practical application. And because of some of the features that they have, they are based on party autonomy, but they put an emphasis on the cooperation between the parties and the need to exchange information, the importance of conservative remedial remedies as opposed to conflictual ones, and also the mechanisms for solving contract disputes in the course of the lifespan of the contracts, particularly with reference to long-term contracts. So this is the first instrument I wanted to introduce, the UNIDROIT IFAD Legal Guide on Agricultural Land Investment Contracts. As I said, it's the second of 3 legal guides developed in partnership with FAO and IFAD for the achievement of sustainable and equitable agribusinesses, so squarely within the SDG 17. And I'm not going to talk about the whole instrument, but particularly how it impacts the sustainability issues. And the consideration of sustainability issues is pervasive in the legal guide for all phases of the life cycle of the investment contract, starting with the formation, the negotiations, the performance, the remedies. And I would like to make 2 examples out of many that we could make based on the legal guide. First of all, in relation to a more general issue of sustainable development, the number 8 of the ESGs, the legal guide may be used to support community development agreements or local employment provisions, as well as outgrower schemes in which farmers on or next to the investment area engage in contract farming with the land investors and therefore have a more active participation and use of the land. And I would also like to emphasize that the first of the legal guides developed by UNIDROIT together with FAO and IFAD is on contract farming. So the second element that I would like to underline is the relationship specifically with climate action and with life on land, because the legal guide promotes not only environmental impact assessments, and the impact assessments were already mentioned in the previous presentation, but it also sets out environmental obligations that contracting parties should consider when negotiating a land investment, in particular a lease contract that is promoted by the guide. And they also include, for example, the monitoring of emissions, which also has a good connection with the other project of UNIDROIT on VCCs that was discussed earlier on in this conference. To conclude, I would like to introduce the ongoing project on international investment contracts. Again, it's a joint venture between UNIDROIT and the ICC International World Business Law Institute. And I would like to focus on what is the purpose of the project and then to unpack this purpose. Exploring at contractual level how international investment contracts, and the definition is contract between states or their controlled entities and private foreign investors, could be modernized, harmonized, and standardized in light of existing uniform law, the UNIDROIT principles, and the ICC standards to address a number of developments in the area of international investment law. So, first point, to unpack this purpose of the project, why focusing on contract? I think this is something that was well emphasized in the first presentation, the growing importance of contracts to organize and protect investments, also based on the criticism that was faced by at least the older versions of the treaties, bilateral treaties, and the growing number of contract-based commercial disputes. So in a way, it's a contractualization of the standards. Second, in light of the UPIC and ICC standards, because these projects, as I already said, are based on existing uniform contractual law principles and rules, and since it's a joint venture with the ICC, also on existing model clauses, but adapted to the specificities of international investment contracts. And this is why the preferred form of instrument for the moment is a soft law instrument with principles, rules, with comments, and then also model clauses. Now, I don't have to deal much on this particular slide because the speaker before me was much more detailed in explaining what were the developments, especially at regulatory level. But this project takes into account the fact that there are developments in international investment law in relation to sustainability, and there is a need for international investment contracts to align with such developments, mentioning the Sustainable Development Agenda of the UN, but also the UNCTAD Roadmap for Sustainable Investment, and the third generation of bilateral investment treaties, which tries to have new context to address sustainable investment, including investors' obligation or at least commitments to adopt best efforts towards sustainability. So how does the project, what can the UNIDROIT ICC future instrument add to this landscape and do to enhance sustainability investment? First of all, one of the possible uses of the instrument is to create a common understanding of some of the more vague legal concepts which are included in the new generation treaties, and create therefore more certainty about rights and obligations in the contract. So the instrument can be an interpretative guidance in the application of domestic law or international standards to investment contracts. Secondly, there is a need to develop contractual rules and clauses to strike a balance between the foreign investors' protections, the state's obligations, and the protection of the public interest and public policies, which is created through investors' obligations or commitments. And finally, there is a need to prevent disputes through adequate contractually agreed mechanisms applicable to obligations both of the state and the investor, among which, for example, adaptation, renegotiation mechanisms, monitoring and grievance mechanisms, which integrate the need to develop, adapt the contracts and the different rights and obligations of the parties, also through instruments such as mediation or arbitration. And we are also in the project developing a due diligence clause, which is developed together with the ICC as a process to develop due diligence in a neutral and balanced way. So I would like to conclude this presentation by thanking you for your kind attention and also by leaving on the screen where you can find more information about all these projects, and of course, very happy to answer any additional questions you might have. Thank you very much.
Thank you very much, Anna. Just to add to this, that the investment contracts instrument and project is generating so much interest that we've created a consultative committee inviting member states to appoint domestic and regional experts. So it's a huge project with a lot of international interest, and perhaps we'll have time to discuss more. So our third speaker is Dr. Li Miao, and she's the legal director of the China Merchants Port Holdings Company Limited. And she's going to give us a local perspective, a more specialized one, particular application of ESG, by talking to us about ESG reporting for the Hong Kong listed companies. The floor is yours.
Thank you, Professor Tirado. Distinguished guests, ladies and gentlemen, good afternoon. Thank you for joining us for this panel discussion on international investment and sustainable development. The topic for my presentation today is ESG reporting for a Hong Kong listed company. I will briefly introduce the ESG reporting guide in the Hong Kong main board listing rules, and then use the ESG report for China Merchants Port Holdings Company as an example. So ESG reporting is the disclosure of environmental, social, and governance data of a company. The report will provide information about the company's ESG activities and their impacts. It is useful for evaluating the sustainability and ethical impact of the company and improving the information available to the investors, the creditors, and other stakeholders so that they could make an informed decision. If companies are required to disclose information on ESG topics, so they will pay more attention to their performance on those aspects. So they will start developing policies, designing programs, and measuring progress. So this will have implications on the company's international investment target and how the company runs their international projects. So according to the data tracked by the European Corporate Governance Institute, until July 2023, 29 countries maintain some degree of mandatory ESG disclosure regulation, including the United States, the United Kingdom, Singapore, Malaysia, Hong Kong, and etc. In 2016, Hong Kong Exchange and Clearing Limited introduced the requirement for listed companies to publish annual ESG reports. Hong Kong listed companies are held to certain mandatory ESG reporting standards. So they include governance structure regarding the board's and management team's oversight, management, and progress review of ESG matters. Explanations on how the reporting principles of materiality, quantitative, and consistency were applied in the preparation of the ESG reports. And the reporting boundaries listing the entities included in the report and the reasons for their inclusion. In Part C of the guidance, there are in Part C of the guidance, there are comply or explain provisions. So listed companies are required to state whether they have complied with those provisions. If a listed company has deviated from any of those provisions, it is required to provide considered reasons for doing so. So next, I will use China Merchants Port's report as an example to explain how it works. So China Merchants Port Holdings Company Limited is a Hong Kong listed company which owns and operates ports in mainland China and abroad. It is required to comply with the ESG reporting requirements. So as one of the mandatory disclosures, the company is required to disclose the ESG governance system and to show how the ESG-related issues, goals, and targets are managed at the company. So here's the chart showing the company's ESG governance system. So as you can see, the board is as the highest responsible body for ESG affairs within the company. The company authorized the ESG committee to identify and implement ESG affairs. The ESG leadership team is the leading and coordinating body of ESG work. And the ESG working team, headquarters, departments, and subsidiaries are the main execution bodies. So another mandatory disclosure is to explain how the reporting principles were applied in the preparation of the ESG reports. Here I will take materiality as an example. So in the ESG reporting guide, materiality is defined as the threshold at which ESG issues are determined by the board to be sufficiently important to investors and other stakeholders that they should be disclosed. So when determining the key ESG issues, the stakeholders will be invited to take part in the process. So the first step is to identify key ESG topics. By exploring the development of port industry at home and abroad, and with reference to the ESG reporting guide and the relevant industry standards, the ESG committee will propose key ESG topics. Then the internal and external stakeholders will have an opportunity to conduct a materiality assessment in the form of an online questionnaire. By ranking the ESG issue from the issue pool according to the degree of their concern. And then the committee will examine the materiality of ESG issues, considering degree of impact on the company, including directors and the management and the stakeholders. The committee then report the assessed key ESG issues to the board. The board will review the assessed key issues. If they confirm that these issues are of higher importance to the company and its stakeholders compared with other issues shortlisted into the company's ESG issue pool, so these issues will be disclosed in the ESG reports. So this explains how the reporting principle of materiality was applied in the preparation of the ESG report. And this slide shows the stakeholders that have been consulted with when identifying the key ESG topics to be disclosed in the ESG report. And these are the environmental issues, social issues, and issues at operational level that has been determined by the board to be included in the 2023 ESG report. So I will take environmental issue number 8, the highlighted one, addressing climate change and carbon emission management as an example to show how this issue is presented in the ESG report. So the report distinguished between physical risks and transition risks. So physical risks refer to risks directly associated with business. So for example, this one, the risk of the increase in the severity of typhoons. So the potential impact of this risk is that it may cause significant damage to the port facilities and cause loss of assets. The port operation may be interrupted and result in reduction in business. So to address this issue, the company took these measures such as formulate typhoon and flood prevention plans, emergency response plans, and etc. The transition risks refer to risks associated with changes in policy, laws, technology, and markets resulting from the transition to a low-carbon economy. For example, the risk of the increase in greenhouse gas emission pricing. So this risk may increase the operating costs of the company, such as carbon tax and carbon trading. To address this issue, the company track and control the energy conservation work of its subsidiaries and promote green development in the process of project planning and design, so as to avoid ecological pollution caused by emissions. And in line with China's goals of carbon peak in 2030 and carbon neutrality in 2060, the company has set the goal of carbon peak by 2028 and carbon neutrality by 2060. The target to achieve carbon peak is further break down to 2 phases. Then the report provides what key actions has been taken by the company in 2023 to help achieve the targets. For example, the establishment of energy carbon management platform, hiring qualified third-party supplier to verify carbon emission data, and provide recommendations for management improvement. So after that, the achievements in low carbon emission was illustrated by data tracked throughout the year. And at the end of the report, there is an index of the ESG reporting guide, which shows where to find the relevant information for the comply or explain provisions in the report. And it also shows whether the comply or explain provisions have been satisfied. So our chosen example cater to like indicator A1.2, and for that indicator, it is marked as disclosed. So this example shows how to satisfy comply or complain provisions. And here are some photos of our ESG initiatives in foreign countries where we have port operation. Due to the time constraints, I will not elaborate on this page, and further information can be found on the company's website. So hopefully, after this presentation, you could get some idea of what an ESG report may look like and what kind of data may be used to evaluate the ESG performance of a company. So with the ESG reporting requirement moving more and more upwards in the agenda of the relevant governing authorities and becoming a trend well underway, it is probably just a matter of time until a business entity is required by law to disclose ESG data, or required by its investors and other stakeholders to provide ESG data. So it will be beneficial to start collecting and analyzing the company's ESG data and build up ESG profile, so as to get prepared amid the fast-changing ESG regulation environment. So that's all I would like to say at this stage. I look forward to your engagement in the discussion session. Thank you for listening.
Thank you. That was very interesting, and the perhaps best behaved panelists I've ever had in my entire life, because they not only complied with time, but they've left us with over 20 minutes for questions, and there are a number of questions, quite a few actually. May I start by asking Anna, just for a minute, to complement Anthony's presentation by explaining a little bit the work done on contractualizing standards along the supply chain in the project on corporate sustainability due diligence. Just a minute, please, thanks.
Thank you very much, Ignacio. Yes, I had focused on the two adopted instrument and project that focused specifically on investment contracts, but actually UNIDROIT has in its portfolio, and we are starting hopefully work on a project on corporate due diligence in the global supply chain, which is based on the request by several organizations working in this area, including the EBRD, but also FAO itself and others. They were interested in having a global perspective on how to contractualize the obligations and the rights pertaining to sustainable development throughout the supply chain. And therefore, it would be a very technical project looking at how you can use contract law, including technology, for example, platforms, in order to ensure that the clauses inserted in the contract are actually applied throughout the supply chain, but also that the adequate mechanisms for solving disputes or for providing remedies are actually applied again throughout the whole supply chain. So we see from the presentation that was done by Dr. Miao that these are concerns that are global. They are not just a European concern with the newly adopted directive, and therefore we think that it's high time for an intergovernmental organization asked to do this work by other stakeholders to engage in this very important development of contractual guidance, again, through soft law. It's a guidance. It will not be a hard law instrument, and it will not be a regulatory instrument, but a private and commercial law instrument.
Thank you, Anna. Okay, so we have plenty of questions. So I'm going to first ask one to Anthony Crockett. Do you see an increase in overlap? I think it's linked with your the question that was the caption for your presentation. Do you see an increase in overlap between public international law principles and private international law investment and contracts?
Yeah, I do. I think, and that's a good question. And I was very interested to hear about the project on investment contracts, because investment contracts are seen, they're sort of coming back into fashion. It was something that was used very commonly in the late sort of 19th century and then into the early part of the 20th century. And contracts themselves were then criticized from a sustainable development perspective. And so things like oil concession contracts, where investors would go and sign a contract that gave them the rights to a particular oil field, in some cases for an extremely long period of time, and then they had provisions in them which would effectively freeze the regulatory regime that would then be applicable to those operations for a very long period of time. And, from a sustainable development perspective, that gets criticized. You say, well, you're not providing any room for environmental or other technical standards to evolve through the life of the contract. And it's interesting, though, that we come back full circle to contracts because of the criticisms that were made of investment treaties, and it's very important that those issues get addressed in the investment contracts, because otherwise we will end up with our privatized system of regulating investment facing exactly the same criticism as we see in relation to investment treaties. And so, and one of the challenges, I think, is about how you go about negotiating them. There's an argument that contracts are better because you can then negotiate in respect of the specific project and the specific investment. And so the provisions you include about sustainability matters can be properly tailored to the particular context. And, I can see the force in that argument, but then equally on the sort of the public interest side, there'll be the concerns about how do we know that those contractual provisions are being complied with? How do we even know that those contractual provisions exist in the first place? Has the contract been made public? And those are some of the challenges that need to be addressed in terms of thinking about the use of investment contracts, in terms of mitigating that criticism, I think, that we saw in the investment treaty context.
Thanks. Actually, of the many, I'm jumping to another one which is linked, which says, let's adjust it a bit, but it says, in your view, do you think the compliance risk of international principles such as guidelines should fall upon states or upon investors or upon both?
Again, a really good question. In a sustainability context, I can think of examples of issues where it will certainly be something that implicates both conduct of the host state and the investor. And that would be particularly the case where the project has been designed cooperatively by the host state and by the investor. So infrastructure, for example, where the government has to be involved in decisions about where the infrastructure is going, if communities have to be moved, if natural resources are going to be affected in some way. You see that those are not things that are completely within the control of a private investor. The government is very involved. And then once an investment is established and operating, there'll be issues where the environmental performance of a particular project or investment, you might have issues of, well, is it being regulated properly versus is the investor complying with their obligations and complying and implementing technical standards. And so it is quite difficult that these disputes will often involve an element of both. When it comes to a dispute, I think there's probably things you can do in the contract as well that allocate those responsibilities in a considered way, which will become more important. And these provisions we talk, I think we're probably going into a period where the provisions around sustainability in the contract will become heavily negotiated. There's been a little bit of a practice, particularly in the supply chain context, where you just have a long appendix of environmental and social provisions that sort of get stapled on the back of the contract at the last minute. But I think particularly in an investment context, if it's a long-term project where the parties are going to need to cooperate to effectively implement all of their obligations, the provisions around sustainability need to be more carefully considered, because you have to think about the full life cycle of the investment.
If I may just add one point, it's the parties, of course, but it's also third-party stakeholders which might be negatively addressed by the fact that the sustainability, that the project is not sustainable and does not follow the standards of sustainability. And this is one of the issues that has to be tackled in contracts. We are trying to do so in our project, and partly also in the investment treaties. So there are a lot of different participants to consider in this respect, more complicated than the usual party-to-party relationship. Thank you.
Yes. Well, in this joint partnership between the International Chamber of Commerce and UNITROA, one of the most likely outcomes is the drafting of model clauses that should facilitate the contractual negotiations precisely in the allocation of risks between compliance and non-compliance. So that is likely to be one of the most beneficial outcomes of the project. Now to you. I think it's linked with proportionality, and I'm going to ask the question and enhance it a little bit. The question is, do you think how best a balance can be struck between promotion of ESG on the one hand and avoidance of overburden reporting obligations and hence costs for companies on the other? And I would ask you perhaps to answer the question, because the answer is relatively easy for listed companies, but what about if the companies are smaller and not listed? Is there a proportionality issue there that you want to comment upon?
Yeah, I'll address the first question first. So to strike a balance, yeah, we do feel like because of the more stricter regulating environment, so the companies are facing more and more responsibilities with these ESG obligations, especially like the taxing. So for example, if this if some countries have levy like heavy taxing for greenhouse emissions, so that's kind of thing that increases our practicing costs. So the second is that it would be good to give the companies some time to adjust to the new regulating, the new regulations, especially like the port industry, because the port industry have like a big impact on the environment. So for example, if we have a new terminal, so it may have like impact on the marine species. So for example, if we build a terminal and it affects like the turtles around that area, so the government may ask us to do like some compensation scheme. So we may have to set up like a nursery for the baby turtles to help them to find a place to hatch, to relocate their hatching places. So that's that kind of the issues we are facing now. We also have like to plant the trees. So because we also, in addition to the ports, we also have like free trade zones. So that's that is relevant to exploring sometimes may need to eliminate some green fields. For that kind of issues, we need to maybe plant more vegetation in some other areas. So I think that's the situation we are facing now. So we are facing more and more specific measures for us to comply with this kind of ESG requirements. It would be helpful, so before the governments implement this kind of regulations, they would have like a consultation period, or maybe give some a longer period to adjust. But sometimes this may come quick, especially like in a jurisdiction we are not very familiar with, and we don't have a how to say that a representative to represent like our interest. So it would be useful if there's such an international organization like UNIJOID that can help design a international treaty, like a guidance like on how the relevant government how they do regulating things. Yes, that's how to balance the burden. Yeah. So the second is one for the smaller, for SMEs. I think they are. Yes. I think they are somehow also affected now because for us, we have like a supply chain management as well. So when we are reporting the our ESG practices, we need to collect data from like our suppliers. So these are sometimes like SMEs. So even if they are not directly required by law to disclose this kind of ESG data, so as to to help their customers to comply with their ESG obligations, so they need to provide some data, some of their the data for their practice as well. So I think maybe in the long run, so the SMEs may also be required to disclose this kind of ESG data, because for environmental thing, it's like a global thing, so no one is outside this problem. Yeah.
Sure, but it does bear a cost, so it has to be proportionate, right? Yes. That allows me to link, staying in the area of SMEs. There's an interesting question says, bilateral investment treaties, international investment agreements currently do not differentiate protection standards between large enterprises and SMEs. In what ways may international investment contracts facilitate the access of SMEs to the global market for investments? I know it's a very general question, but if you might want to link it with whether this, the contractualization of these standards should affect the same way smaller entities or larger investors or not, perhaps?
A couple of very brief comments, I guess. Investment treaties are accessible to investors large and small, and so in that sense, it's one of the benefits of investment treaties is they're available to everyone, and they ought to facilitate investment whether an enterprise is large or small. I think one of the challenges with investment contracts is negotiating investment contracts with a government, that if you think I'm a multinational negotiating an investment contract with a government, and that might be a challenging negotiation. It might require quite a lot of resources to achieve your goals in the negotiation. If you're an SME trying to negotiate an investment contract with a government, you're in an even weaker position, and so it's investment contracts are not going to have perhaps the same advantages for SMEs as they might have for multinationals, unless you can somehow address the power imbalance that is going to exist in those negotiations.
Thanks. Okay, there is a question for everyone, which will be the last one. But before that, there is one specifically for you again, and it's very specific for your case, and I think it probably begs for a quick answer. But I think the answer to it might be something we can extrapolate to the effect, or to the to the effects that compliance with ESG has in people. So the question is, Dr. Lee, have you seen ESG reporting draw in younger investors in China Merchants Port Holdings Company Limited?
Sorry, could you rephrase your question?
Have you seen ESG reporting draw in younger investors in China Merchants Port Holding Company? I guess what it's trying to say is the fact that you comply with these reporting standards and you make public all the good things that you do has increased investment by younger people who, in your equity, I imagine, or maybe debt securities as well, that would really care about ESG.
For that question, I won't be able to answer that question because I won't be able to see like the age group who bought the shares of this company. But I think it is quite useful to attract investors if like we upgrade like overall the rating of our ESG rating, and I think it is useful for financing. So nowadays the banks they have like face quite restrict regulations on ESG matters. So when they are considering whether to invest or borrowing money or lending money to this company, they will really look at this kind of criteria, like the ESG rating. Yeah, and I'm glad that our company has been, it's performing better and better now. So it's like B. It's not A yet, but it's very close to A. Yeah, but because for port, it's very, very difficult to reduce like the greenhouse emissions and the energy, but we are saving the energies now, like by using more electricity than the fuel, things like that.
I guess the question behind the idea behind the question, which is a very important one, perhaps the key one, is you incur higher costs by complying with ESG requirements, and that, however, is compensated by the reputational improvement that the company receives, and people are willing to invest in the company precisely because you are compliant with the ESG. I guess that was the idea behind it.
Yeah, I see where your question coming from, like the.
I mean, I'm interpreting the question, so I could be wrong, but okay. So last question to everyone, because we do have 3 minutes, according to. So it's question to the panel: does the lack of concrete definition of ESG conflict with sustainability principles that companies need to incorporate into their business dynamics? Does anyone want to take a stab at this? I mean, go on.
I won't guarantee that I'm necessarily directly answering the question, but I think related to what you asked Dr. Lee about ESG reporting and the burden, the sort of reporting standards that exist have not been harmonised, and so that's obviously a big burden for companies, particularly if they might be subject to more than one. And there is still a lot of debate about definitions, etc. I think we will probably move away from ESG as the definition towards sustainability as a label for things, but it still needs to be unpacked and subsidiary definitions adopted that people can think about and use effectively and use in contracts. And so projects like the ones that UNIDO are working on are, I think, very important in terms of translating some of that. A lot of the language has been developed by accountants, and unfortunately, language developed by accountants can be difficult to then put into contracts, for example, in a straightforward way that makes sense to people.
Okay, thanks all for that. Right, so it only remains for me to thank you all very much and ask the audience please to join me in congratulating the panelists for the excellent session.
All right, thank you very much, our moderator and speakers. So please kindly remain seated first, and let's have a group photo. All right, so please look at our official photographer in the center for a group photos. Thank you very much for giving us a lot of insight and important information about the international investment and sustainability. All right, a big round of applause for our moderator and panelists once again. Thank you very much. All right, ladies and gentlemen, we're going to take a short break right now. So please come back at 3:30 p.m. for our final panel discussions. So for those who are here in person, feel free to enjoy some light refreshment that we have prepared for you right outside of this conference hall. And for our online participants, please come back at 3:30 for the final session. See you soon. Ladies and gentlemen, the final sessions will begin shortly. Please kindly be seated. And just a gentle reminder for all of our audience, please kindly turn your mobile phone into silent mode. Thank you very much. 各位來賓，我哋最後一場嘅專題研討咧，馬上就會開始㗎啦。有請各位盡快就座，並且將你哋嘅手提電話調至靜音模式。多謝合作。各位來賓，我們最後一場的討論環節馬上就會開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。謝謝大家。 Ladies and gentlemen, welcome back. So here comes the final panel discussion on the topic of building bridges by strengthening engagement in the Asia-Pacific region. So already on stage, we have our moderator, Dr. James Ding, JP, Chair of the APAC Economic Committee, and a Law Officer, International Law, Head of the International Law Division of the Department of Justice, Hong Kong SAR. And also joining Dr. Ding, we have Ms. Solongu Bayasaikant, First Deputy Chief Cabinet Secretary of the Government of Mongolia, Mr. William Bridie Watson and Professor Mei-Ling Huang, co-directors of the UNITRA Asian Transnational Law Center, and also Professor Zhao Yun, JP, representative of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law, and Associate Dean of the Faculty of Law at the University of Hong Kong, and also Dr. Ling Yang, Director of the Hong Kong International Legal Talents Training Office of the Department of Justice of the Hong Kong SAR. So just like our previous session, if you have any questions for our speakers, please kindly submit the question through our QR codes right here on the screen or on the table or around the hall. And for our online participants, the QR code should be shown on your screen. And now without any further ado, I'm going to pass over the stage to Dr. Ding.
Good afternoon. Welcome back to the last, but certainly not the least, session of the summit today. This is indeed the biggest panel for the day with a very gender balanced 6 people panels here. And we have distinguished panelists from the government and also from international organizations. This panel will discuss how to strengthen engagements in the region. And speaking about engagement in the regions, in my capacity as an APAC Economic Committee Chair, we stress the importance of engaging the regions, engaging the APAC economies. And one of the most common or popular means of engagement is to do it through capacity building. And my department, Department of Justice, has also been contributing to a lot of capacity building work over the years. And I believe that some of the speakers will later also present some of our work on capacity building later. These panel sessions will start with presentations by our speakers. And after that, we will have panel discussions or Q&A sessions. As you know, we are in the final sessions before closing. So we need to be very careful about the time. So I urge our speakers to keep your presentation within the time limit so that we can have some interactive Q&A afterwards. Without further ado, let me introduce our first speakers. Ms. Bayasaikant, the first Deputy Chief Cabinet Secretary of the Government of Mongolia, to share with us some of the experience of Mongolia. So the floor is yours.
Thank you. Good afternoon all, and first of all, I would like to thank the co-organizers for inviting me today, and especially our dear colleagues and friends from UNIDRA, with whom I had have an opportunity to meet almost 2.5 years ago, I think. And we are very proud member of UNIDRA, I think 65th and the latest member state joining the UNIDRA. So in my presentation, I will just show the experience of Mongolia, how we are trying to improve our regulatory environment and also creating more legal certainty for cross-border business transactions that would be conducive to promoting more investment into Mongolia. But before that, I will give some background information on Mongolia. So Mongolia transitioned from a communist country to market-based economy and democratic governance in 1992. In the last 30 years, we have achieved a lot. So our GDP per capita increased significantly, but unfortunately, inequality has increased. Our economy is quite dependent on a mining sector, if you're familiar with Mongolia. Almost 90% of our export revenues come from mining sector. And obviously, mining sector requires significant investment, and this requires also balancing of the interests that were subject of the previous panel. So I listened to the discussions at the previous panel on the ESG issue and sustainability issues, especially in relation to the international investment agreements between multinational companies and also host governments. That's exactly the same challenge and tensions we also face when we try to negotiate long-term investment agreements with multinational companies. So since 1990, we also managed to improve Human Development Index and average life expectancy, but we also face similar challenges in terms of urbanism and also concentration of population in the urban areas. And we are now focusing on more balanced development, focused on regional development related issues. And also, I think partly due to the mining sector, we also face significant challenges in improving transparency and governance in our key sectors, where there is integrity and corruption risks are present. So we also quite focused on improving the transparency and governance, and also to reduce governance risks. And the government's priority is really to sustain economic growth so that we will address the inequality and also create more prosperous future for our people. And obviously the pandemic created a big challenge, but we're hoping to have a sustainable economic growth for the next decade or so that our people enjoy better living conditions. And currently our government is implementing a midterm new economic recovery policy. And within this policy, we are looking at 6 key issues that are becoming bottlenecks for economic growth, including key infrastructure developments, border crossing capacity, also energy infrastructure, and all this hard infrastructure related investments obviously require a significant investment. And to ease the investment environment and also attract more foreign direct investment into our country, we are also focusing on government productivity and increasing transparency, and also creating a legal environment that's more conducive to private investment in the key economic sectors. So we also are looking to implement a newly adopted public partnership law, and that obviously includes all the issues that have been a subject of the previous panel. And the key issue, obviously, for international business transactions and large-scale investment agreement is obviously legal certainty and the sanctity of contract. And that's where I guess we will have similar, challenges. And compared to Hong Kong, Mongolia is a civil law country, and we have codes that set out relevant rules for enforcement of the contract. And when we talk about doing business environment, one of the key issues that private investors raise is obviously there should be more legal certainty for enforcing contracts, and there should be more smooth dispute settlement mechanisms in place. So Mongolia is working to also improve the legal environment for enforcing contracts and the building trusts for entering into contracts between private entities. And obviously, it's helpful to have international standards and also international conventions in place to encourage private entities to invest more into our country, especially when we talk about the investment in the hard infrastructure projects, long-term investment contracts. The key concern investors often raise is obviously enforcement of the contract and also sanctity of the contract, whether Mongolia will honor its commitment or not, whether the long-term contract will actually survive the time, the duration of the contract. And currently, these legislative acts govern private law aspects of doing business in Mongolia. We adopted the arbitration law latest in 2017, which is based on the UNCITRAL model law on international commercial arbitration. And our contractual framework contracts between commercial entities are governed by civil code that was approved in 2002, and the dispute resolution environment is governed by civil procedure code approved in 2002. Our Ministry of Justice is currently working to revise these two sets of codes, and there has been discussions whether Mongolia should have a commercial code separately from the civil code. And we have been discussing with Ignacio and other colleagues from UNITRA, and they are kindly advising us that it's actually, not the legal term that's important, but the substance of the law that's more important. So we are currently working on these legislative reforms. We obviously looking at the international standards and also other countries' experiences on improving this legislative framework. And also to attract more investment into Mongolia, we're looking to other countries where there's a more developed stock exchange and larger capital markets where the liquidity is not a problem. For example, Hong Kong Stock Exchange or other similar markets. And for that, we are interested in having a dual listing of Mongolian companies, both at the Mongolian Stock Exchange as well as the Hong Kong Stock Exchange. For that, we are also looking, having a closer look at our company law, whether our company law provides equal level of protection for minority investors comparable to what is afforded under the rules in Hong Kong. And we are also working to adopt international norms and conventions that would also create more legal certainty for our investors and also for our private companies. So we become a member of the UNITRA in 2023 as a 65th member state, as the latest of the three sister organizations that was described by Professor Ignacio earlier today. We become member of the Hague Conference on Private International Law in 2021, I believe. And we also try to actively participate in the ongoing work of the UNCITRAL at the United Nations. In terms of the key conventions that are relevant to this today's discussion is that Mongolia is a party to UN New York Convention on Enforcement of Foreign Arbitral Awards of 1958, and we also party to the 1980 Convention on International Sale of Goods, as well as Electronic Communications Convention. And for UNITRA, we ratified the Cape Town Convention, the aircraft protocol, and we also looking to ratify and studying on the MAC protocol and also the rail protocol that has been also discussed earlier today. And for HCCH, the Hague Conference, we ratified the Upsteel Convention and there's an Adoption Convention. And we're also looking to ratify the later versions of the Convention on Civil Procedure-related matters. And it's one thing to create enabling environment for enforcing arbitral awards, but I think it's a completely different thing to also change the substantive law of the host country. Obviously, Mongolia, as a civil country, we are also seeing a lot of convergence from common law countries, especially in the contract law area. Most of the cross-border business transactions, loan transactions are governed by common law, especially English law or New York law. And dispute resolution is obviously often cases in international arbitration centers. And that creates this big convergence between the civil law and the common law traditions of especially contract law. And we're seeing increasingly more influence of common law in our contract law. And we're hoping that with the cooperation with UNITRA especially, we will create more legal certainty for our legal practitioners as well as foreign investors for our substantive law, especially on the contract law. So we're also looking very closely at the UNCITRAL principles on the contracts. And I think that this year is 30th anniversary, right? So we are a little latecomer, but also hoping to improve our civil code and commercial code with the view, with the reference to these international instruments that are made available by UNITRA and other international organizations. And in respect of the future cooperation, we're hoping to have more capacity building and technical assistance work with UNITRA and its member states. And I was very interested in the secondment program that was established between the Department of Justice, Hong Kong, and also UNITRA. So whenever I look at the capacity building programs and try to develop capacity building programs at our government, I often look at the other countries as an example and try to raise funding for that. So I think we can learn a lot from Hong Kong and Department of Justice. And with that, I'm hoping to build closer cooperation with our counterparts, with other member states of the UNITRA, also with UNITRA. And it's great to be here in Hong Kong and to meet old friends from UNITRA and also to meet new friends. So I think my time is up, and thank you for your attention, and it's nice to meet you all here. Thank you.
Thank you. Thank you for sharing the experience of Mongolia. And as we just heard, Mongolia has been working very closely with UNIDROIT. So I will now invite our speakers from UNIDROIT, the Asian Transnational Law Center, the two co-directors, Will and Mei Ling. I will give the floor to Will first. Yeah.
Perfect. Thank you. Good afternoon, everyone. It's my pleasure to spend the next few minutes introducing UNIDROIT's work in recent years to engage and promote our work in the Asia-Pacific region. UNIDROIT, under the leadership of Secretary General Tirado and Deputy Secretary General Veneziano, are deeply committed to increasing our membership, the implementation of our instruments, and our engagement with governments, with academia, with lawyers, and with the private sector in the Asia-Pacific region. I think the fact that for the second time, the organisation of this conference here in Hong Kong, in cooperation with our wonderful friends at the Department of Justice and the very high-level delegation that UNIDROIT was able to send, is a strong indication of the commitment that UNIDROIT has to engaging in this region. So I'm very lucky to have followed the wonderful presentation by Ms. Bayer Saikan, who, under her leadership, has brought Mongolia into the UNIDROIT family, and in some ways is a model country in terms of the kinds of benefits that countries can get if they become UNIDROIT member states. As you see here in this slide, UNIDROIT has 12 member states in the Asia-Pacific region, and as very proudly put in bold, our two most recent member states, Mongolia and Singapore, who both joined last year, are both from this region, and we hope to grow that membership even more in the coming years, because we're very proud of the 12 member states we have, but there are obviously several very prominent countries from the Asia-Pacific region that are still yet to join the UNIDROIT family. This is in part because, as you see on the second part of this slide, we allow non-member states to ratify our treaties. The Cape Town Convention has 25 contracting parties from the Asia-Pacific region, over double our number of member states. So clearly the benefits of UNIDROIT's work are being felt in the Asia-Pacific region, and we work very hard to promote the benefits of our treaties. But as set out by Ms. Bayer Saikan, states cannot fully utilise the benefits that UNIDROIT offers unless they become members. They cannot participate in negotiations. They cannot second members of their judiciary, members of their government to UNIDROIT. They can't fully participate, they can't promote, they cannot make proposals for the work program unless they are member states. So there are many benefits that comes with UNIDROIT membership, notwithstanding the fact that we do allow non-member states to also ratify our instruments. But it's not only membership and ratification that reflects the involvement of the Asia-Pacific legal community in our work. Here you have a list of our current legislative projects, the projects that UNIDROIT is currently undertaking, which will eventually result in new international instruments. And you can see that every single one of these projects has at least 2 experts drawn from the Asia-Pacific region. We are including expertise from this important and diverse region in our work, and that is a deliberate choice in the formulation of these different groups. And I think this ensures that diverse perspectives from the Asia-Pacific region are reflected in the negotiation of our instruments, so at the end of the process, we don't just have a European approach or a North American approach, we have a fully global approach that can ensure our instruments can be implemented across the world, not just in common law, not just in civil law. And of course, Asia is particularly important in that regard because you have such a diversity of legal traditions in this region. It is not a dominant civil law or common law. You have many different approaches, and it is essential for standard-setting bodies such as UNIDROIT to take into account and benefit from the expertise of these diverse experts in the formulation of our instruments. UNIDROIT has a strong historical link with academia and with education. We have one of the greatest private international law libraries in the world that we're very proud of, and this non-legislative aspect of UNIDROIT's work is also reflected in our engagement with Asia. As has been noted several times today, we're very proud of our secondment agreements with the DOJ of the Hong Kong Special Administrative Region, as well as MOFCOM. We also have secondment agreements with other non-Asian governments. We have 13 academic cooperation MOUs with institutes across the Asia-Pacific, including Hong Kong University here. And I think this second point is particularly interesting, that of the 300 applications we had around the world for scholarships and internships in 2025, 46% came from Asia. nearly half, as compared to the entire rest of the world, came from this region, which shows the growing interest from universities, from students, from professors, from practitioners to come and spend time at UniDois to learn more and negotiate and be part of our instruments. In addition, we have 26 Asia-Pacific correspondents from 10 different member states, and we are currently in discussions about the possibility of hopefully in the future opening up Asia-Pacific Liaison Office for UniDois here in Hong Kong. Because we're a small organisation, we have to use our resources strategically, and we utilise regional organisations to ensure maximum impact in promoting our instruments. And in particular, our most successful regional engagement has been over the last 8 years with APEC, where we've been very grateful for the cooperation and collaboration with Hong Kong, which is currently chairing the Economic Committee under Dr. Ding's leadership. You can see here a list of all of the different projects that UniDois has engaged in over the past 8 years. The Secretary-General himself has attended several APEC meetings, and it is proving a very important forum for UniDois to promote its work to 24 different member economies. And in fact, next year there'll be a specialist workshop on the MAC protocol in Japan under the auspices of APEC. And this is a wonderful opportunity for UniDois to promote its work to a broad range of different economies within the region. You can also see that we are not only using APEC, we are also engaging with ASEAN, the Asian African Legal Consultative Organization, our friends of the Asian Infrastructure Investment Bank, and the Asian Development Bank, all of which UniDois has visited their headquarters for consultations in the last 24 months. And last but not least, we must mention our friends, our three sisters. We're very pleased to have our representative from the Hague Conference here on the stage with us today. All three organisations work extremely closely to promote each other's work, to work harmoniously, and to ensure that our work can have the greatest impact around the world. There are a list of different initiatives we have here, but I was also very pleased to see in Ms. Bayasai-Khan's presentation that Mongolia is also taking into account different instruments from all three organisations, and that's certainly something that UniDois encourages very strongly. At this point, I'll hand over to my excellent colleague, Ms. Huang, and my co-director of the Asian Transnational Law Centre to introduce our most recent initiative on engagement in the region. Thank you.
Thank you very much. So, distinguished guests, ladies and gentlemen, good afternoon. It's a great pleasure and a great honor to be here during Hong Kong Legal Week, an event that so beautifully embodies the spirit of cross-border legal collaboration and innovation. My name is Mei-Ling Huang. Currently, I'm a Principal Legal Officer at UniDois. Being here feels especially meaningful because Hong Kong is such a dynamic hub for legal and financial exchanges, as this morning we heard. So today I'm excited to introduce an initiative of UniDois that embodies the same spirit, the Asian Transnational Law Centre, or ATLC. So let's start with a quick look at ATLC logo, which, like the center itself, has a purpose-driving design. As you can see, ATLC is part of UniDois Academy, and its logo is made up of arcs that form a circular ring. This ring symbolizes Asia's essential place on the world stage, faithfully reflected here in Hong Kong, where East meets West. The two intersecting arcs in the logo signify transnational connections, much like a bridge, which is what Hong Kong Legal Week is all about. So this bridge represents ATLC's core mission, fostering collaboration, coordination, and friendship across legal community in Asia. So to achieve these goals, ATLC will engage in several activities. We will organize consultation and promotional events to boost awareness and understanding of UNIDROIT's project in Asia. We also recognize the accessibility is the key. So ATLC will be translating UNIDROIT's legal instrument into Asian languages. This will make this essential resource available to a broader audience, bridging knowledge gaps and promoting adoption and implementation across the region. Another core focus of ATLC is the establishment of a research platform to cultivate legal talent in Asia. I will be speaking in more detail about this next Friday. So in long term, we hope that ATLC will serve as a global platform for scholars, practitioners, and students can engage with translational legal issues relevant to Asia. In essence, ATLC is a forward-looking initiative aiming to address key legal challenges. As the Commissioner Cui this morning mentioned, we are in the era of change. So using a global approach, as my colleague Will mentioned, to enhance legal harmonization and foster a more integrated and cooperative legal environment. The ATLC is based at UNIDROIT headquarters in Rome, a beautiful city. Of course, as many of you might know that. The center is led by two co-directors, myself and Mr. Wayne Braden Wilson. We are honored to have been appointed as founding co-directors for the first 3 years, with supervision from our UNIDROIT Secretary General, who is also present today, Professor Tirado. To further guide our work, we've formed an advisory committee comprising of distinguished Asian legal experts who help ensure that ATLC's efforts align with the needs of the region. So let me briefly outline the core activities we are focusing from 2024 to 2026. The first part is library publications and translation. The second one is secondment, scholarship, internship, and research opportunities. The third one is events, consultation, and meetings. And ATLC also will launch the International Commercial Arbitration Moot Competition, applying the UNIDROIT principles of international commercial contracts. So these activities are designed to establish a strong foundation for the ATLC and support our mission across Asia. And before we wrap up, allow me to share a quick announcement. I'm thrilled to announce that the launch of ATLC seminar series in January 2025. So I warmly invite each of you to join us for these seminars. Here, I've also included the poster of our first seminar, which will focus on digital assets, which we talked about this morning. And what better to extend this invitation than at Hong Kong Legal Week, where the spirit of collaboration and cross-border exchange is truly alive. Thank you for your attention. Thank you.
Thank you, Will and Mei-Ling. As Will just mentioned, that in Asia, there are many different diversities, different legal systems. We have civil law, common law, sharing law. So there's a lot of work that UNIDROIT can do to build bridges in these regions, including what Mei-Ling just mentioned about ATLC work in translating the instruments in different languages in Asia, and also doing more research work, etc. I think it will be useful. We also hear from the Hague Conference on Private International Law, which has its regional presence in Hong Kong. So maybe Professor Zhao can share your experience about how you build the bridges through the Hague Conference Regional Office for Asia and Pacific. Professor Zhao, please.
Thank you. Thank you, Chair. Good afternoon, ladies and gentlemen. It is a great honor for me, in the capacity of a representative for the Regional Office of the Asia and the Pacific of the Hague Conference on Private International Law, to speak on this very important event. I'm very pleased to see that Mongolia is already members to 2 organizations already, 2023 to the UNIDROIT, but we are very proud that Mongolia joined 2 years before, 2021, to the HCCH. But of course, I think we're also very happy to see that the UNIDROIT has a lot of initiatives, very good initiatives, I think including the center and academy, and also I think a seminar series. This really shows about the very important role of the synergy and a lot of important promotion and capacity building efforts. So today I'm going to look into the important role for the regional office. As the title shows, that we are going to look at how the regional office can help the promotion of the organization and also the conventions. This, of course, also can provide very good occasions for us to look into the views and also share the views regarding the role of regional office. This slide basically shows about why we use HCCH. HCCH is abbreviation for our organization, Hague Conference on Private International Law. As you can see, there are English version and the French version. So we basically took the 2 letters from each. So we have the HCCH. The rapid expansion of cross-border transactions, mobility of people and family relationships within and outside the region would all benefit from the support of an international legal framework. The HCCH has taken this important role to facilitate international transactions and protect the interests of vulnerable parties involved. The HCCH conventions help to promote cooperation among courts and other authorities that are indispensable in the age of globalization and progressive regional integration. In general, if we look into the framework of the HCCH, we will look into 3 pillars. One pillar is basically touches upon the family issues. The second very important pillar deals with the transnational litigation. And third pillar deals with the corporate and financial law issue. So we will promote these 3 very important pillars in our region and beyond. The HCCH so far has more than 130 years of history, currently headquartered in Hague, the Netherlands, with 2 regional offices, one in Argentina for Latin America and the Caribbean, which was established in 2005. The other one here in Hong Kong for Asia and the Pacific, established in 2012. Regional offices comprises an essential part of the permanent bureau of the HCCH. When compared with other regions around the world, the Asia-Pacific region is unique in many aspects. First, it is a region made up of many countries, and their geographical dispersion makes travel, including dispute resolution, more expensive. Second, the region is populated with common law, civil law, and hybrid legal systems. Third, multitude of different languages is spoken, making it more difficult for parties to access and understand the laws and procedures of countries they engage in business with. And fourth, the region is also made up of varying levels of economic growth, resulting in considerable differences in the sophistication of court practices and procedures. It is self-evident that the Asia-Pacific region is vital to the HCCH. The regional office for the Asia and the Pacific, which we abbreviated as ROAP, R-O-A-P, set up 12 years ago, plays a role to strengthen the ties between the HCCH and the states in our region. It is now located in the former French mission building, the historic building, as you can see from the left side of the slide. The ROAP has aimed to promote the HCCH and its conventions by increasing regional knowledge and awareness of the value of the membership of the organization and the usefulness of the conventions to the region. The objective is to encourage other nations in the region to join and adhere to the HCCH conventions. Additionally, the regional office brings benefits in terms of assisting the states in the implementation of the conventions. As the HCCH's influence becomes more and more global, a growing number of Asia-Pacific countries join the HCCH and all its conventions, both benefiting from and contributing to the HCCH. Since the year of 2000, the number of HCCH member states has grown rapidly. Among the 44 new members, 16 are from Asia. This sum is quite astounding, and the growth potential here can be underestimated and deserve further exploration. Since the establishment of the RoLAP from December 2012 to 2024, the number of HCCH members increased from 72 to 91. So altogether, there are 19 new members, with a major contribution from Asia-Pacific nations, in total 9 from the region. The total number increases from 13 members in 2012 in our region to 22 members in 2024, taking a share of 24% of all members. If we look back, that's in 2012, the percentage was 18%. So the new members include Vietnam in 2013, Singapore and Azerbaijan in 2014, Armenia in 2015, Saudi Arabia in 2016, Kazakhstan 2017, Uzbekistan in 2020, and then in 2021, we have Thailand and Mongolia. The growth was as much slower. If we look back, from 2002 to 2012, only two new members. So from 11 to 13, but from 2012 to 2024, from 13 to 22 members. Despite the geographical proximity, the countries in our region represent a vast range of cultural and legal traditions. The HCCH Convention seeks to bridge diverse cultural and legal traditions and offer a viable framework for cooperation between countries within the region and with those beyond the region. This is a context in which the RoLAP was conceived. The increased membership based in the region will bring wider representation of a diverse range of legal traditions to the HCCH and help the HCCH to develop new instruments better adapted to meet the needs of the region. It will also assist in raising revenue, help to reduce expenses for the services already provided to state parties in the region which are not yet members to the HCCH, and facilitate ratification or accession to the HCCH conventions by the states in our region. The value of a convention, as well as its value to individual state parties, will generally increase in proportion to the number of states, to the state member states, to the convention. This slide shows the number of members to the HCCH core conventions. Increasing the number of state parties to the conventions in our region will also provide additional opportunity for enhancing certainty and predictability of cross-border private, commercial, and financial transactions and relationships. Promoting judicial and administrative cooperation and reinforcing protection of children and other vulnerable persons in trans-border cases. Benefits will accrue within the region and also between states and outside the region. After the establishment of the RoLAP in 2012, 19 states from the region became contracting parties to one or more of the key HCCH conventions, For example, 9 states joined the Apostolic Convention. Mongolia, of course, is member to this convention, and 8 new members for the 1965 Service Convention, and 6 new members from the region for the Child Abduction Convention. I think Mongolia has already been the member to 3 conventions, and I look forward to more conventions which will be applicable to your country. So to sum up, a regional office in the region will help to raise awareness of the international organization and strengthen the links between the organization with the countries in the region. More specifically, the regional office, first of all, helps to promote universality, which is a shared vision for progress. The essence of a ROAP's existence lies in its commitment to increasing awareness of the organization and its conventions, fostering a deeper understanding among states and stakeholders in the Asia-Pacific region. ROAP's role in supporting states on their journey towards HCCH membership, facilitating visits, and providing crucial introduction to the HCCH conventions has been proven vital in fostering stronger ties between states in the region. ROAP actively organized and participated in an array of events, such as meetings, seminars, workshops, and conferences, bringing together experts, diplomats, and representatives to discuss and celebrate the significance of HCCH instruments. For example, the HCCH Asia Pacific Week emerged as a highlight, providing a dynamic platform for stakeholders to engage in meaningful discussions on HCCH projects and celebrate milestones such as the 130th anniversary of the organization and the entry into force of the 2019 Judgment Convention in Hong Kong last year in 2023. Furthermore, ROAP maximized its impact by integrating its activities into large events, where the spotlight on international legal matters showcase the HCCH's work on a broader stage. The engagement with law professors and students through seminars and workshops underscore our commitment to knowledge dissemination, nurturing the legal minds of tomorrow. Second, a regional office can help to promote inclusiveness. As collaborative synergy for global impact, ROAP actively promotes the engagement of states and stakeholders in a normative, non-normative, and governance work for the organization, fostering cross-cultural understanding and collaboration. Partnership with international organizations in the region, for example, the ELCO, which William has just mentioned, and APEC, I think these are the organizations which we work very closely with. These organizations, of course, are very important for us to look into new members to the organizations and the conventions. And partnership with these international organizations have been a cornerstone for the collaboration, not only strengthening institutional ties, but also contributing to a broader dialogue on international legal framework, contributing to the final realization of ensuring that the views and concerns of states in the Asia-Pacific region are well represented. Last but not least, a regional office can assist and ensure the proper implementation and operation of the instruments in the Asia-Pacific region, nurturing sustainable partnerships. The role of ROAP as a direct point of contact for states seeking information and advice has been instrumental in providing tailored post-convention services and assistance. It also actively contributes to the development and translation of publications and other materials into the language in the region, fostering a culture of compliance and adherence. Ladies and gentlemen, as we continue our journey, regional presence not only strengthens the organization's presence in the region, but also amplifies its influence in the Asia-Pacific region. The success of our endeavor lies not only in the number of conventions adopted or events organized, but in the enduring impact we make on the legal fabrics of our region. Through increased awareness, strategic collaboration, and proactive engagement, we can position the international organization as a cornerstone of legal harmonization, providing a framework that transcends national boundaries and promotes a shared understanding of justice and cooperation. So with this, I conclude my presentation. Thank you very much. Thank you.
Thank you, Professor Zhao. Your presentation has clearly demonstrated the value of regional presence for in the international organizations like the Hague Conference, like CCH, in increasing the number of members in the regions and also increasing the number of contracting parties to the CCH conventions. You also mentioned some of the capacity building work of the Hague Conference and by RoAP in particular. And talking about capacity building, perhaps we can hear from our last speakers on the panel about some of the capacity building work that Hong Kong has been doing and what Hong Kong will do further. So may I now invite Dr. Yan to the stage. Yeah.
Thank you, Dr. Ding. Good afternoon, ladies and gentlemen. It's my great honor to join this panel. I'm Yang Ling, the director of the Hong Kong International Legal Talent Training Office. And actually, today is my second working day for the DOJ. And 2 weeks ago, I was speaking for the Hong Kong International Arbitration Center to promote Hong Kong as an international dispute resolution hub. But today, it's my great honor to represent the new office, actually just the newly establishment this October, and it was addressed for the last chief executive, the address of last year. So today, I think this is for me, I think it's for all of the audience today, the first time to share the office, the vision, and our thoughts on the strengthening engagement through capacity building in this vibrant region by deepening existing connections and building new collaborations. So today we have a very great panel today. So from the first speaker, Ms. Sanogong, we have seen, we have learned from her that the significance of enhancing engagement through legal exchange. From your slides, I note that the Mongolia adopted the UNCITRAL model law on international arbitration in 2017. I would like to share with you the Hong Kong Arbitration Ordinance. We adopted the first version of UNCITRAL model law on international arbitration in 1980s. So I think in this regard, we have a lot of things, potential to work together in the future. And I also appreciate the crucial role of engagement initiatives of UNIDROIT, especially from the new initiative from co-chaired by Mr. Huang Meiling and Mr. William. You just mentioned the co-vision of this new initiative. And after sharing of Professor Zhao Yun, I'm thinking whether your institute or your initiative should take Hong Kong as a new bridge and Hong Kong as a new city to set up your new regional center here in Asia. And for Professor Zhao Yun, I know Professor Zhao Yun for many, many years when I was teaching in the East China University of Political Science and Law 16 years ago. And Professor Zhao Yun visited East China University as the very first, the pioneer from China, from mainland China to be a university professor in Hong Kong to show the Hong Kong as an international legal talent hub, not just for Hong Kong local talent, but also for mainland Chinese talent here. So I'm very thankful and learn a lot from our distinguished panelists today. But today, I would like to share with why the importance and how the importance of the capacity building for the strengthening engagement in the region. So in fact, the capacity building is one of the targets of Global 17 of the United Nations Sustainable Development, strengthens the means of implementation of revitalized global partnership for sustainable development. So in this first paced global landscape, the call for capacity building in the Asia-Pacific region resonates louder than ever. The increasing demands of a competitive economy, the imperative of sustainable development, and the challenge of a rapidly changing society underscore the necessity of continuous growth and the enhancement of our collaborative capacities. To address these challenges, it is of utmost importance that individuals, institutions, and international organizations enhance their capacity through transformation. By emphasizing the capacity building, we aim to empower individuals and organizations to realize their potential and to bridge the gap between aspiration and achievement. Through tailored program, mentorship, and knowledge sharing initiatives, it is our vision to cultivate a culture of continuous improvement, innovation, and excellence. The legal community in Hong Kong stands out for its high level of professionalism, expertise, and diversity in language and experience, which provides Hong Kong with a unique strength for capacity building. As late September this year, Hong Kong boasts a significant number of qualified legal professions. I would like to share a number of figures today. For example, in Hong Kong, we have more than 11,400 solicitors and around 1,700 barristers, including over 100 senior counsel, recognized for their exceptional legal skills and experience in handling complex legal matters. In addition to the local practitioners, Hong Kong also hosts around 1,470 foreign registered lawyers from 30 jurisdictions, further enriching the legal landscape with diverse perspectives and international expertise. Moreover, Hong Kong provides a platform for over 70 foreign law firms to establish their presence in the city and engage in cross-border legal work. Furthermore, a growing number of Hong Kong legal practitioners obtained practice qualifications to provide legal service in 9 mainland cities in Greater Bay Area, 大湾区. With over 500 GBA, Greater Bay Area, 大湾区 lawyers from Hong Kong and Macau, these legal professionals with dual qualifications would navigate the legal landscape of not only Hong Kong, but other parts of the Greater Bay Area, facilitating cross-border legal transactions and collaborations between the regions. Another unique advantage of Hong Kong and the principle of one country, two systems in our common law system, which has been guaranteed by President Xi to be continued beyond 2047. Hong Kong, as the only common law jurisdiction within China, offers high quality of multiple legal services. Hong Kong has the strong and warm support from the Central People's Government, as all of you have heard this morning. For example, the National 14th Five-Year Plan, the outline development plan, 14规划, for the Guangdong, Hong Kong, Macau, Greater Bay Area, support Hong Kong to reinforce and enhance its status as an international legal and dispute resolution service center in the Asia-Pacific region. With this diverse legal community and strategic position as a global legal hub, the next question is, what can we Hong Kong offer to the community? We believe that Hong Kong, as a super connector, possesses the significant potential to facilitate meaningful connections and synergies among legal professions, organizations, and jurisdictions across the world. To better leverage Hong Kong's advantage of being backward motherland and connected to the world, 背靠祖国，连通世界, and to nurture high-quality legal talents with an international perspective, the Hong Kong SAR, with the strong support of the central government, built close cooperative relationship and made standing secondment arrangement as a lot of professors mentioned this morning and this afternoon with various international legal bodies, including the SCCH, UNIDROIT, UNCITRAL, and AIIB. This program provides valuable opportunities and exposure for local legal talents to enhance their knowledge of international legal matters. The Department of Justice has also signed various MOUs and exchange of letters with various jurisdictions and international organizations, such as AALCO, ALCO, and the Asia Pacific Economic Cooperation, APEC, to provide professional exchanges and capacity building programs. In addition to supporting the capacity building work of SCCH, UNCITRAL, and UNIDROIT. Furthermore, to contribute in nurturing legal talents in foreign-related legal matters for the country, the Department of Justice has been working closely with the Supreme People's Court, the Ministry of Justice, State-Owned Assets Supervision and Administration Commission of the State Council, the Ministry of Commerce, and the various mainland universities to strengthen cooperation and exchange between the mainland and Hong Kong legal talents. The Department of Justice also co-organized training courses and seminars with the Hong Kong Bar Association, the Law Society of Hong Kong, and the Asia Academy of International Law. The Department of Justice, led by the Secretary for Justice and the Deputy Secretary for Justice, has also been leading the local legal and dispute resolution professionals in visiting the mainland, the ASEAN countries, and the Belt and Road countries, promoting professional exchange among the region. Riding on the existing foundation, the Hong Kong International Legal Talent Training Academy will coordinate the existing capacity building programs and relevant resources, and together with the current secondment programs with various international organizations, strengthen the role of Hong Kong as an international legal service center and fully utilize Hong Kong's unique advantages as a common law jurisdiction. The Academy will organize practical legal training courses, seminars, international exchange activities, and more to facilitate talent exchange among the Belt and Road regions. The Academy will also provide training for talents conversant in international law, common law, civil law, and national legal systems, and of other Belt and Road countries. Training program organized by the Academy would consist of both regular courses and tailor-made or specialized courses with a focus on legal practice and procedure, which is distinct from those courses with a primary focus on legal theories and academic subjects. The programs would cover a wide range of legal systems, including Hong Kong common law, including substantive and procedural law, of course, civil law, mainland law, international law, etc., and a array of legal topics such as international arbitration, commercial mediation, climate change, green finance, intellectual property, court or arbitration procedures, as well as the advocacy skills. Target of the programs and the Academy include, but not limited to, 1, mainland legal professionals, including judges, government officers, and diplomats, legal experts, and academics. 2nd, legal professionals and government officers from law-related departments in other jurisdictions, for example, countries in Middle East and ASEAN countries. And 3rd, Hong Kong local legal and dispute resolution professionals. We are truly honored that the Hong Kong International Legal Talents Training Expert Committee has been set up with 17 distinguished legal experts from different jurisdictions. For example, the Secretary General of Professor is in this international advisory board. This 17 distinguished legal experts will be formed 3 advisory boards to advise us in developing, in training, and capacity building programs and strategies. Their extensive knowledge and experience is invaluable as we strive to formulate practical and user-friendly projects for legal talents and promote exchange among talents and across the regions. The Academy will be formally launched this Friday, 8 November. So all of you are invited to join our launch this Friday. And I think this will represent a unique opportunity for us to strengthen engagement across the various sectors and jurisdictions, while the Academy is striving to realize its vision and mission, but we cannot achieve this alone. We need your support. So the support from every one of you will help us develop innovative platforms, foster collaborative projects, and create a dynamic learning environment. So together, we can cultivate a community that not only meets the challenge of today, but also prepares for the opportunity of tomorrow. Hong Kong is prepared to contribute to the capacity building needed in the region and beyond. We have seen Yulidua as an excellent partner for collaboration, and international organizations could also make a good use of Hong Kong as ideal base to strengthen the engagement in the region and beyond. So last but not least, I would like to invite all of you to join our launch day this Friday. Also in the future, our Academy and our office are looking forward to working with every one of you. Thank you.
Thank you, Dr. Yan. We still have a few minutes for Q&A. We have received a number of questions, but in light of the time, so I will only ask one question to each of our panelists. The first question, maybe I will start from Dr. Yan first. Someone asked, would the Hong Kong International Legal Talents Training Academy consider any future collaboration with UniDRAFT and other jurisdictions in the region, such as Mongolia?
Okay, this audience is something, I thank you very much for this question. So for Yulidua, For Yulidua, I just mentioned Secretary General Professor Tirado is one of the 17 advisory expert committee, and we will have first the meeting for all the committee members this Thursday afternoon. So I believe between the Academy and the Yulidua, we have a lot of things to cooperate. For example, training in some instrument about Yulidua in Asia-Pacific region, use the Hong Kong as a base. And for Mongolia, as I just mentioned, as arbitration as an example, Mongolia in Asia, we have seen the rise of international arbitration. And Hong Kong is a pioneer and one of the leading hub in Asia-Pacific region. I think between Mongolia and Hong Kong, at least for arbitration and mediation, we have a great potential, a lot of things to do together. So if Mongolia would like to, our Academy, our office would like to design some tailor-made program for Mongolia. So this is my short answer.
Thank you. The next question is for Professor Zhao. You have mentioned that the RoAPT has done excellent achievement in increasing the number of consenting states to Hague Conventions and also the number of member states. Is there a similar trend for the other regional office in Latin America?
Thank you very much. Before I respond to this question, I would like to add something to the Dr. Yang's answer. Of course, there's always areas for collaboration between the HCCH and also your office. When we talk about the HCCH, we have 37 international conventions, 2 protocols, and 1 soft law document. So there's a lot of areas which we can work on. Now, when it comes to the 2 regional offices, the regional office in South America was established in 2005 with the Asia Pacific office in 2012. If we look at the chart that I showed, we basically find out the largest portion actually came from Asia Pacific region, but we also similarly, we can find out the South American office, the Latin American office also has a similar trend, although when it comes to its absolute number, statistic is a little bit lower than Asia Pacific region. That also, of course, has some relevance with regard to the member states in different regions in Latin America or Asia Pacific region. But also we look into the member states that have already been the members already, so that some rooms which we can work on. So in a way, I think we can see the trend is quite clear. It's moving up. I think this also shows about the efforts that has been made by the regional officers. It really helps the promotion and also capacity building. And also in the long run, we can find out that the work will become more difficult because more members already but there are still areas we have to work on. It takes a long time. I still remember, I think Professor Tirado has mentioned that for Thailand, it took 15 years for them to agree to join the HCCH in 2021. So it takes time. We have to build up. Slowly, we have the capacity building, and they will get to know about the benefits of international organizations such as UNIDROIT and also HCCH. Thank you.
Thank you, Professor Zhao. And the next question is for the two co-directors. In what ways the ATLC can assist in the implementation of UNIDROIT instruments and other international law instruments?
Thank you. So the ATLC is focused on engagement with non-government. Obviously, UNIDROIT is an intergovernmental organization. Our clients, our stakeholders are our 65 member states. But of course, it's private international law. So it's also important for us to form a strong connection with academic experts, with practitioners, with the private sector. So the main value of the ATLC will be in through things like the seminar series, by allowing Asian experts to come to UNIDROIT to discuss how our instruments can assist in Asia, to do events here in Asia for these private sector and academic stakeholders, and also to provide essentially a pool of funding for us to bring some of Asia's greatest talents, whether it be from the private sector or from academia, to come and do internships and scholarships and spend time at UNIDROIT, at our law library, to generate this better knowledge about how our instruments work and how they can assist in the legal economic infrastructure, and then come back to their home countries and implement our instruments. So that's how we think it'll assist in achieving UNIDROIT's mission. Thank you.
Thank you. So our last question is for Ms. Bajasakan. Do you think that regional presence of international organizations would be useful to enhance legal exchanges and technical assistance? And would you welcome a regional presence of UNIDROIT in Asia, for example, the liaison office mentioned in Hong Kong by Will just now? What do you think?
Sure, I think that will definitely assist in strengthening cooperation between the UNIDROIT and its member states, especially Asia-Pacific region represents very diverse and wide-ranging cultures and countries, and definitely it would help. So first, when we tried to join UNIDROIT, we visited Rome, and obviously Rome is such a nice city, it's always nice to visit, but definitely I think regional presence would assist in strengthening the cooperation. And I guess the key issue when we talk about the building bridges is that I think by having a closer cooperation among different legal jurisdictions, we also aim to create trust between the business entities, and the trust is the key for economic cooperation and bringing people closer. So without trust, I think it's very difficult to create economic opportunities and to create more closer cooperation between countries in the Asia-Pacific region. So I think that's the key value of having a closer cooperation in the region would be really to create trust among our people.
Thank you. We will certainly welcome you to visit Hong Kong if there is an office here. So with that, I think that it's time for us to conclude these sessions. Could you join us to give a big round of applause to our panelists? Thank you.
Thank you very much, our moderator and panelists. So please remain seated and let's have a good photo first. So please kindly look at our official photographer in the center for good photos. Thank you very much for giving us a lot of insight. All right, thank you very much, our moderator and panelists. So please kindly exit the stage and be seated off stage. Thank you very much. So after we have heard from a lot of our speakers, giving us a lot of insight, to officially conclude the first event of the Hong Kong Legal Week 2024, I would like to invite Mr. Jiang Guoquan, SPS JP, Deputy Secretary for Justice of the Hong Kong SAR, to come up on stage to deliver his closing remark. Ladies and gentlemen, let's give a big round of applause and welcome Mr. Jiang.
Professor Tirado, distinguished guests, ladies and gentlemen, it's a great honor for me to deliver the closing remarks of the Asia Pacific International Private Law Summit 2024, a remarkable event co-organized by UniDraft and the Department of Justice of the Hong Kong Special Administrative Region. I'm especially delighted to see Ignacio and Anna again in person today. It brings back my memories of my visit to UniDraft Secretarial in the beautiful city of Rome last year, where I attended an insightful conference co-organized by UniDraft and the Chinese Embassy in Italy. I still recall the generous hospitality extended to me by Ignacio and Anna during my visit. I sincerely hope that we have been able to reciprocate that same warmth and hospitality during your time here in Hong Kong. Today's summit has been nothing short of inspiring. We have been privileged to hear insightful presentations from distinguished officials, industry players, and experts from Hong Kong and overseas, including high-level officials from several renowned international organizations of UniDraft, Asian Infrastructure Investment Bank, and the Hague Conference on Private International Law. We are also honored to have had a senior official from Mongolia to share her insight, which have further enriched our discussions. The quality and depth of these presentations have been commendable, addressing critical issues pertinent to the evolving landscape of international private law. The topics explored by our expert panelists are both timely and relevant not only to Hong Kong, but also to the Asia-Pacific region and beyond. I'm confident that the insights shared today will contribute significantly to ongoing discussions within our legal communities and other stakeholders. As we reflect on today's summit, one overarching theme has particularly stood out, that is, the importance of legal certainty and predictability. In an increasingly globalized world, where cross-border transactions are growing in volume and complexity, the harmonization and modernization of private law are more important and essential than ever. Reducing legal uncertainties is not merely an academic or technical exercise. It directly benefits businesses by enabling them to operate with greater confidence and facilitating smooth cross-border commercial activities. Legal certainty and predictability fostered by international private law will therefore be a springboard to opportunities for the Asia-Pacific region, as encapsulated in the theme of today's summit. In our first panel, we delve into the need for a consistent approach to the legal treatment of digital assets across jurisdictions. The advent of technologies such as distributed ledgers has paved the way for cryptocurrencies and other digital assets, which are now integral to various sectors of our economy and financial markets. In order to unlock the potential of the digital economy, a clear and certain legal framework is vital. Such clarity instills trust in technology, ensures platform resilience, and protects the rights of consumers and business alike. In this context, the UNIDROIT principle on digital assets and private law, which provides a common framework addressing legal issues related to the holding, transfer, and use of digital assets, are particularly relevant to Hong Kong and Asia Pacific. Today's discussion offered much to consider about integrating international principles with local laws in each jurisdiction to achieve harmonization and consistency. As an international financial hub, Hong Kong is committed to promoting the integration of real economy and digital economy and fostering a development of the digital economy. The benefits and role of harmonized secure transaction law in promoting economic growth across the Asia-Pacific region was discussed in panel 2. Secured transactions are essential for businesses seeking access to credit and working capacity. As a leading international trading hub with a robust legal system, Hong Kong is the prime destination for mainland and overseas enterprises establishing their international headquarters to manage offshore trading and supply chain operations. In fact, Hong Kong ranks at the top globally in terms of international trade and business legislation according to the World Competitiveness Yearbook 2024 by the International Management Development Institute. Our expert in panel 2 examined the importance of international instruments supporting secured transactions, while exploring UNIDROIT's contribution to secured transactions laws, such as the Convention on International Interest in Mobile Equipment and its various protocols, as well as the recent adopted model law on factoring. Such efforts are crucial for enhancing access to credit for business across the Asia-Pacific region to unleash our economic potential. The experts at panel 3 brought our attention to the need for reducing legal uncertainties surrounding international investment contracts for both states and private investors. In this regard, the panel introduced the UNIDROIT's ongoing international investment projects, which seeks to modernize, harmonize, and standardize international investment contracts by developing clear guidance to foster consistency in these vital agreements. It also addresses recent developments in international investment law, such as the increasing focus on corporate social responsibility and sustainability. These topics are of particular relevance to Hong Kong, given its role as an important gateway between China and the global market. Hong Kong's unique arrangements with mainland China enhances its appeal as a jurisdiction for international investment and arbitration. Investments from Hong Kong into the mainland China enjoy the substantive protection offered by the investment agreement under the Mainland and the Hong Kong Closer Economic Partnership Agreement, the CEPA. Moreover, we are the first common law jurisdiction where parties involved in arbitration seated in Hong Kong can seek interim measure from mainland courts, such as assets preservation. This synergy between Hong Kong's legal infrastructure and its strategic relationship with mainland China not only bolster investor confidence, but also further strengthens Hong Kong's position as a leading center for international legal and dispute resolution services within the Asia-Pacific region. Finally, Panel 4 discussed building bridges to strengthen engagement and capacity building has been identified as a key to strengthening engagement in the Asia-Pacific region. This involves not only improving legal infrastructure, but also developing skilled professionals capable of handling the capacities of international private law. The panel highlighted the significance of legal cooperation and legal talents development. Capacity building initiatives among international organizations and Asia-Pacific economies are crucial in equipping our region's government officials, petitioners, and other stakeholders with the skills and knowledge needed to navigate the complex international legal landscape. Amid the growing demand of legal expertise driven by increasing international trade, these initiatives foster collaboration and nurture skilled legal professionals, thereby improving access to justice regionally and beyond. Hong Kong is deeply committed to enhancing its status as a regional hub for capacity building. With a strong pool of legal and dispute resolution professionals who possess extensive international experience, the Department of Justice has been actively involved in organizing and supporting various trainings and development programs across different areas of law and practice. For example, we have co-organized or supported multiple editions of the investment laws and investor state mediator training, and the China-ALCO Exchange and Research Program on International Law in Hong Kong. As noted by our Secretary for Justice during his opening remarks, the Hong Kong International Legal Talent Training Academy will be officially launched this Friday, and we warmly invite all of you to join us to witness this significant moment. Building on our strong foundation in capacity building and our close collaboration with UNIDRAFT and other international organizations, the Academy will regularly offer practical training courses, seminars, and international exchange programs aimed at promoting collaboration among legal professionals, judges, and government officials throughout Asia Pacific and beyond. Already in the pipeline for the Academy is to support the organization of the second edition of the Hague Academy of International Law's advanced course in Hong Kong. So ladies and gentlemen, it's my pleasure to announce that we have successfully concluded the Asia Pacific International Private Law Summit 2024. The success of this summit is a testament to the collective efforts and dedication of UNIDRAFT, my colleagues at the Department of Justice, and your active participation. I extend my heartfelt gratitude to everyone who contributed to making this summit a resounding success. As we wrap up today's event, we also mark the end of the first day of the Hong Kong Legal Week 2024. We warmly welcome you all to participate in the exciting events we have prepared for you throughout this week. Thank you once again. I wish you all an enriching experience throughout the Hong Kong Legal Week 2024. For those visiting abroad, I hope you enjoy your time in Hong Kong. Thank you very much.
Thank you very much, Mr. Jerome, for your closing remarks to officially conclude our summit today. So, ladies and gentlemen, the Asia Pacific International Private Law Summit 2024 has come to an end. On behalf of the International Institute for the Unification of Private Law, UNITRA, and the Department of Justice of the Hong Kong SAR, we would like to express our sincere gratitude to our moderator and speakers for their invaluable contribution. So, should we all give a big round of applause to our moderator and speakers one more time? Thank you very much. We would also like to thank you all of our participants, both online and in person. Thank you very much for your active participation. So we appreciate your feedback on this conference. So please scan the QR code on the screen or around the hall to fill out the evaluation form. So please note that this QR code is different from the one that you used to submit the question. So please make sure you scan the right one. So before you leave, please remember to take all your personal belongings with you. If you have picked up a SHI headset, please return it to the counter at the entrance. Also, if you intend to obtain CPD or ALE points for the summit, please remember to sign out at the reception and complete the evaluation form. 各位來賓，亞太國際司法峰會2024亦都圓滿成功，再一次多謝大家嘅蒞臨，期待喺香港法律周2024嘅其他活動再同大家見面。各位來賓，亞太國際司法峰會2024圓滿成功，再次感謝大家的蒞臨，期待在香港法律周2024的其他活動和大家見面。Thank you once again for joining us, and we look forward to seeing you again in our other events in the Hong Kong Legal Week 2024. Have a wonderful evening. See you.